Holy henna. Yesterday's hearing came on the heels of a whole bunch of denied motions, and you may recall that all of that came on the heels of Karen Read's interviews with Ted Daniels. I know a lot of you are very zoomed in on what occurred during the hearing yesterday, but we really do need to zoom back out to these three things I just mentioned to fully understand the implications, or the possible implications, of what's going on here. We'll get into what happened in court yesterday, but first I want to look into the legal processes that evolved up to the point where Judge Canoni threatened the defence counsel with grave consequences last week. Because that's how we get to focus on the patterns of misconduct, rather than getting carried away with Meatball's psyop. So if you followed all of the goings-on before Trial 1.0, you'd know what I mean by Meatball's psyop. He was essentially having a conniption fit over the defence making public statements on the courthouse steps. And so the prosecution sought to prevent that by making motions to the judge, and she ended up ordering both sides to refrain from making public comments, wherein Meatball completely ignored the court orders and issued what we now refer to today as the hostage video. Here's a little clip I made, generally having a go at Meatball's hostage video.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Read is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. What is happening to these innocent people, these witnesses, is wrong, and it needs to stop.
All fun aside, it's because of those series of events that we knew every time Karen speaks to the media, the prosecution's going to have a new conniption fit. There's always a retaliatory action from the prosecution. So let's zoom out a little bit to wrap our heads around what's going on there and why I'm calling it Meatball's psyop. Shout out to Zelda Kelly for coining the phrase. The Commonwealth represents the people. So when we say Massachusetts versus Karen Read, we're saying the people of Massachusetts versus Karen Read. But Meatball, overwhelmingly, does not have the people's support to prosecute Karen Read. We saw that reflected in the online polls during Trial 1.0. Not only does Meatball not represent the people of Massachusetts in this case, but nearly the entire world. And so he sets about trying to counter any positive publicity that she gets. This is why he had the judge order that both sides are not allowed to make public comments prior to Trial 1.0, and also why you heard Mr. Brennan refer to the media to his right during his little PR stunt last week that resulted in Judge Canoni threatening the defence counsel. When you put these patterns together, the timing of the prosecution's accusations of false representations and Judge Canoni's threats, coinciding with the filing of the habeas petition, its expedited review on the same day, and the defence's public media statements, this all strongly suggests retaliatory motives. So let's talk about whether a retaliation argument can be framed under the due process, First Amendment and Sixth Amendment protections to challenge both the prosecution's misconduct and the judge's biased response. So first we might ask, is there a legal basis for a retaliation claim? And the short answer is yes. A judicial or prosecutorial action taken against a defendant or defence counsel in response to protected legal activity, such as filing a habeas petition or exercising free speech, is unconstitutional. The First Amendment protects the defence counsel's right to publicly discuss legal matters. The Sixth Amendment ensures the defendant's right to legal representation without judicial interference. And the 14th Amendment, the Due Process Clause, prevents courts from retaliating against parties for engaging in legal advocacy or seeking relief from a higher court. is there key case law that supports this proposition? Absolutely. Under North Carolina v. Pierce, 1969, it says a court cannot impose harsher treatment on a defendant in retaliation for exercising a legal right. Under United States v. Goodwin, 1982, it says retaliatory actions against a defendant for exercising the rights violates due process. And under Giglio v. United States, 1972, it says prosecutors cannot engage in misconduct, including false accusations against defence counsel, to undermine a fair trial. So to relate that case law back to what's happening here, the habeas petition was filed and expedited by the federal court the same day Judge Cannoni issued her threats. The defence's media appearance highlighted misconduct that the prosecution sought to suppress. You know, that little hiccup where Trooper Fanning was in charge of the jury. Nothing to see here, folks. And the judge's threats, paired with the prosecution's unsupported allegations, suggest coordinated retaliation rather than legitimate concerns. So, rather than doing what Mr. Brennan did and speculating on a bunch of crap, how might the defence be able to prove that there is a pattern of retaliation going on here? Well, we've already identified protected actions taken by the defence, which is filing the habeas petition and speaking to the media, and we've already identified adverse actions taken by the judge and the prosecution. And that includes Judge Cannoni issuing threats of grave consequences the same day the habeas petition was expedited. The prosecution accused the defence of false representations without evidence or affidavits to support their arguments, shifting the focus away from their own misconduct. And then the judge may consider extreme sanctions, which it looks like she's considering removing the defence counsel, or she could bar the FBI witnesses, and that would cripple the defence's case. On top of all of that, we also have all these motions that were denied. We'll come back to that, but rest assured they do play a role. In essence, the sudden nature of these actions, directly followed by the defence's legal and public advocacy, suggest retaliatory intent. So the next step for the defence would be to show a lack of justification for the prosecution's claims, which I believe they did very well during the hearing yesterday. Notwithstanding, the prosecution has not produced any evidence to support its claims of false representations, whilst making false representations itself. Defence provided supporting case law and a full tabbed history proving the representations were accurate. And the fact that Judge Cannoni refused to scrutinise the prosecution's own false representations shows a bias in enforcement. And so, collecting evidence of selective enforcement would help to show a lack of justification for both the prosecution's claims and the way Judge Cannoni is looking at it. Now, the last step would depend on how Judge Cannoni rules on all of this. If she does anything but deny the prosecution's motion, it's absolutely going to cause harm to the defence. If Judge Cannoni removes Alan Jackson or any of the pro hac vices, it violates the defendant's right to choose her own counsel. Under United States v. Gonzalez-Lopez, 2006. I'm pretty sure, I don't remember exactly because I was driving and listening through headphones, but I'm pretty sure Alessi raised that specific case law. Secondly, if she bars the FBI witnesses, that will prevent the defence from presenting key exculpatory evidence under Chambers v. Mississippi, 1973. When you consider the prosecution's three-card Monty tricks, as described specifically by Lally pre-1.0 trial, then you can completely ignore Mr. Brennan's representations that he doesn't care if the FBI witnesses do testify. He is absolutely hoping that Judge Cannoni applies yet more sanctions to the FBI witnesses. Surprisingly, this does fall under Double Jeopardy rules, but we'll come back to that as well. The last thing to consider here are what are all the possible ways that the defence could raise retaliation arguments. The first option is they could file an emergency motion alleging judicial and prosecutorial retaliation, where they could demand that the prosecution provide factual support for its allegations or withdraw them. The defence could cite Carolina versus Pierce and the United States versus Goodwin to argue that sanctions against the defence in response to lawful actions constitute unconstitutional retaliation. Another option is to request a federal court order preventing retaliatory sanctions. Under Bracey versus Gramley, 1997, they could argue that the judge's conduct is evidence of bias and necessitates federal oversight, in which case the federal court could intervene. And if that type of intervention comes about, then requesting the judge's recusal would probably be a smart move. That would mean that she wouldn't be the judge who oversees her own dismissal a second time round. If the federal court has to intervene, it will be taken out of her hands entirely. We'll cover this in more detail shortly. In essence, there is a strong basis to make retaliation arguments, given the timing of the prosecution's claims and Judge Cannoni's threats in relation to the habeas petition filing and speaking publicly. Those arguments would address retaliatory actions violating due process, the right to counsel, and the right to present a defence. If you recall, the last time the defence made a recusal motion, Judge Cannoni judged herself and came to the conclusion that she was not biased. But as we just suggested, federal intervention could actually prevent her from judging herself and coming to her own conclusion. In Massachusetts, as in most jurisdictions, a judge typically rules on a motion for their own recusal unless a higher court intervenes. Given that Judge Cannoni previously denied her own recusal, the defence must take additional steps to ensure the recusal issue is not solely in her hands, i.e. taken at federal. This would involve referral to a higher judge or appeals court. They missed the opportunity to do this last time. They could have, but they passed it over. But they can make a new recusal motion, which obviously she will deny again. But this time, the defence absolutely should appeal it immediately. Case law that supports this would be Caperton versus A.T. Massey Cole, 2009, which states a judge must recuse if there is a serious risk of actual bias, and Bracey versus Gramley, 1997, where due process violations require an independent determination of judicial bias. Another option is to simply put in a recusal motion and then seek an immediate interlocutory appeal if she refuses to recuse herself a second time. Massachusetts allows interlocutory appeals in cases where a recusal denial would result in unfairness. This means that if Judge Cannoni refuses to step aside, the defence can file an emergency petition with the Massachusetts Appeal Court or Supreme Judicial Court seeking an order for her recusal. The defence should argue that there is reasonable basis to question her impartiality, requiring immediate appellate review before Trial 2.0 proceeds. Again, there is case law that supports allowing her to decide her own bias would irreparably harm the fairness of the proceedings. It falls under Liticki versus United States, 1994. Judges should not preside over cases where their impartiality is in doubt. In Re Murchison, 1955, no person should be a judge in their own case. Another option might be to add to the current federal habeas petition a request to block the judge's involvement in the case forthwith, or they could file a completely separate emergency injunction. The federal courts may be inclined to intervene if Judge Cannoni's bias has impacted constitutional rights, such as due process or right to a fair trial. The defence could argue that Massachusetts' refusal to provide an impartial judge violates fundamental rights under the 14th Amendment. Essentially, if the state's remedies fail, it is absolutely in the purview of the federal courts to look into Judge Cannoni's recusal as part of a broader due process violation. In previous videos, we have talked extensively about the judge's repeated bias. This would strengthen the case for recusal. Situations where she has favoured the prosecution or issued disproportionate sanctions. It can all be supported by transcripts in the court record showing disparate treatment of defence versus prosecution. It could also include any public statements, rulings, or conduct that suggests personal involvement in the case beyond judicial neutrality. Roll. Those Venmo payments to Judge Bev from Commonwealth witnesses might actually play a role after all. Under Massachusetts Code of Judicial Conduct, Rule 2.11a, a judge must disqualify herself if she has a personal bias concerning a party, she has knowledge of disputed facts outside the record, and her impartiality might be reasonably questioned. So, just to wrap up what we've just learned here, is that the defence can seek higher court intervention to prevent Judge Cannoni from ruling over her own recusal. Judge Cannoni ruling on her own bias is fundamentally flawed and undermines the fairness of her proceedings. The defence should request that a higher court, not Judge Cannoni, decide the recusal motion. If she refuses to step aside, an interlocutory appeal should be filed, and if the state courts do not intervene, defence can ask for the federal courts to intervene, either through habeas or an emergency injunction. As with all of the possibilities that we discuss on my channel, none of them is a certainty. The defence is made up of a team of brilliant minds, and they've all got a strategy, where it may or may not include saving certain arguments for certain parts of the process, be it in state court, appeals court, or federal court. Just because you have a hand to play doesn't mean you need to play it. Now, discussing what happened in the trial yesterday and what Judge Bev may rule is going to raise more discussions about emergency appeals and interlocutory appeals. So we'll get into discussing the trial first and then the options that Bev's got in front of her, and then we'll come back to which appeal applies to which decisions. But before we talk about the hearing, we still have to talk about the flurry of denials for motions 1 to 10 submitted by the defence last week, just before Cannoni had her conniption fit and outright threatened them. You may recall, while Miss Little was giving her arguments as to why defence is entitled to such things as metadata and hash values, etc., Judge Bev asked her, is the prosecution expected to create metadata when none exists? But rather than creating a reasonable excuse as to why she might deny that motion, she actually revealed that she herself acknowledges that she may well have accepted tainted evidence to be used at trial. We talked about her acknowledging this in previous videos, but in denying the motion, she has essentially offered a, let's say, compromise, which I'll talk about next. But the issue here in denying these motions is that the metadata had to exist. All computers and devices create metadata for every single file stored on them, so it had to exist. Judge Bev's acknowledgement that it doesn't exist comes with its own implications. Her refusal to allow the defence access to metadata, evidence logs, and expert oversight in copying additional video evidence raises serious constitutional and procedural issues. These denials violate the defendant's due process rights under Brady v. Maryland and Giglio v. United States, interfere with the defendant's right to confront the prosecution's evidence, and raise concerns about prosecutorial misconduct, evidence tampering, and discovery violations. The importance of metadata and evidence logs in digital discovery includes two key points. Metadata is critical in evaluating the authenticity, integrity, and chain of custody of digital evidence, particularly video files, and every digital file contains metadata, including creation and modification timestamps, device and software used to record or edit the file, and any alterations or tampering. By denying metadata access, Judge Cannoni is preventing the defence from verifying whether the prosecution's evidence has been altered or selectively provided. Under these precedents that I just mentioned, Brady v. Maryland, 1963, the prosecution must disclose all exculpatory evidence to the defence. And Giglio v. United States, 1972, the prosecution must disclose any information affecting the credibility of its evidence. And of course, we know the application here. If the metadata contradicts prosecution's claim about a video or photograph's authenticity or screenshot, the defendant has a right to that information. By denying access, Judge Cannoni is preventing the defence from evaluating whether the evidence has been manipulated. With regard to denial of evidence logs, this prevents a proper chain of custody review. Digital evidence logs track how digital files have been stored, accessed, and modified. Without an evidence log, the defence cannot determine whether the prosecution's video evidence is an original file or a copy, the files have been altered, deleted, or selectively provided, or there were unexplained gaps in evidence handling. How about unexplained gaps in the actual video itself? Obviously that's relevant. By denying defence access to evidence logs, Judge Cannoni is shielding the state from scrutiny regarding possible evidence manipulation. This also applies to the chain of custody regarding all the other evidence, not just digital evidence. Under Arizona v. Youngblood, 1988, the state must not suppress or destroy evidence that is material to the defence. And under California v. Trombetta, 1984, defendants are entitled to examine original evidence for potential exculpatory value. So to summarise, if there are missing logs, timestamps or altered files, the defence has the right to challenge the admissibility of the evidence. Under the judge's own questioning, she admits that the admissibility of the evidence is probably questionable, and preventing access undermines the ability to contest the prosecution's claims about what the video evidence actually shows. In that same motion, the defence suggested that their expert should oversee any further copying of prosecution's files, and in denying the defence expert oversight, creates a one-sided discovery process. A court should not allow the prosecution unfettered control over how digital evidence is copied and provided to the defence. By excluding the defence expert from observing the copying process, the prosecution is able to alter files before they are provided, withhold crucial metadata, and prevent independent verification of evidence integrity. This creates a fundamentally unfair process that favours the prosecution and undermines the adversarial system. Under Melendez-Diaz v. Massachusetts, 2009, defendants have the right to confront the reliability of forensic evidence. And under Crawford v. Washington, 2004, the Confrontation Clause prohibits the prosecution from presenting evidence that the defence cannot independently challenge. So, essentially, by barring expert oversight, Judge Cannoni is preventing the defence from verifying whether the prosecution copies of digital evidence are complete and unaltered. With regard to strategy, Patrol 2.0, these rulings create significant grounds for appeal and potential habeas relief based on due process violations. Given the available options to defence, we'll get a clue into what their strategy is by how they respond to all of these denials for chain of custody. So as a pre-trial response, they could file an interlocutory appeal, challenge the denial of metadata, evidence logs, and expert oversight. Or they could request an evidentiary hearing to determine whether video evidence has been modified or selectively provided, or they could demand in-camera review of the evidence logs and metadata by the judge or an independent third party. I'm going to hazard a guess, because they didn't do any of this pre-trial 1.0, they're probably not going to do it pre-trial 2.0, and they probably have a different strategy. They could respond to this during the trial by objecting to the introduction of video evidence without a chain of custody foundation, or they could cross-examine prosecution witnesses on the lack of metadata and logs, or they could argue that the prosecution's refusal to disclose metadata and logs creates an inference that the evidence has been altered. And so what we did see in Trial 1.0 was cross-examination of the prosecution witnesses on the lack of logs and metadata. What we didn't see was any argument that the prosecution's refusal to disclose those things created an inference that the evidence had been altered. It would have been great in closing statements. And then, of course, as I mentioned yesterday, there's also post-trial relief that they could respond with. That would be to raise the prosecutorial misconduct and suppression of exculpatory evidence under Brady. They could also challenge the admissibility of video evidence due to the lack of verifiable chain of custody, and they could also argue that the exclusion of defence experts violated the defendant's right to a fair trial. So to wrap up, Judge Cannoni's rulings are unconstitutional and strategically favour the prosecution. Metadata and evidence logs are critical to verifying the authenticity of digital evidence. By denying access, Judge Cannoni is shielding the prosecution from scrutiny and preventing the defence from contesting potential evidence tampering. These rulings violate due process and the defendant's right to confront the evidence against them. If Trial 2.0 proceeds under these conditions, it sets the stage for immediate repeals and habeas challenges. As it stands right here, right now, today, they actually do have grounds to file an emergency interlocutory appeal challenging these discovery denials. They also have grounds to demand an evidentiary hearing to establish whether the prosecution has properly preserved the integrity of its video evidence. And then they also can prepare a post-trial strategy for challenging evidence admissions if these rulings are not reversed. If we don't see any action whatsoever on any of these things, it's almost guaranteed that they have a post-trial strategy. Now, with regard to Judge Cannoni's compensatory ruling, that having the police department video record their actions while making copies for defence is actually unreasonable because a ruling does not adequately safeguard the integrity of the evidence and raises multiple concerns about due process, chain of custody, and fairness in discovery. So let's step through these one at a time. Why video recording the copying process is insufficient. Firstly, because video cannot capture key digital forensic issues like metadata or alterations. So essentially, if you're holding a video camera and filming what they're doing, that video that you're filming has its own metadata. It can't see the data that's on the computer, it can only see what you're doing. You literally have to access the computer to get that digital metadata off the computer. So anyway, metadata is a fundamental aspect of digital forensics and cannot be captured by video. Metadata records timestamps, file origins, modifications, and system properties. Video surveillance cannot document or confirm the authenticity of metadata. Here's an example. A police officer could copy a modified and altered version of a file onto a new device, and the resulting video of them performing that action would not show that the copied file is not the original. Only a forensic expert monitoring the process in real time can verify that the file's metadata is preserved. Case law supports this. Under Mendez-Diaz v. Massachusetts, 2009, the defendant has the right to confront digital forensic evidence, including digital files. Under Bullcoming v. New Mexico, 2011, the Confrontation Clause requires that the defense have a meaningful opportunity to challenge the state's evidence. In summary, video recording the process does not allow the defense to challenge whether the files were altered before copying. A forensic expert should be present to verify the integrity of the digital evidence. And secondly, police video recording their own actions creates a conflict of interest. The police department is a party to the case and should not be responsible for self-monitoring. If any manipulation occurs during the copying process, the police would be monitoring themselves. A video controlled by the police can be selectively edited as well, or missing crucial details, just like all of the other evidence that they're trying to put in. For example, the police could copy an altered file while the video shows nothing suspicious, and the police could later claim that a technical issue prevented recording key parts of the process. Case law that supports this. Arizona v. Youngblood, 1988. The state is responsible for preserving evidence in a manner that ensures reliability. And California v. Trombetta, 1984. The defendant has a right to independent verification of evidence handling. In summary, there is no independent oversight of the police's copying process, making it unreliable. The defense should have its own forensic expert present to monitor evidence handling. And lastly, this ruling creates an unfair and one-sided discovery process. The prosecution has full access to original evidence, but the defense gets an unverified copy. If the prosecution had concerns about digital forensics, they would demand expert oversight. The defense is being denied the same ability to challenge evidence that the prosecution enjoys. Case law that supports this is Wardius v. Oregon, 1973, which says discovery rules must be reciprocal. The prosecution cannot demand rights that the defense does not have. In summary, by preventing the defense from having expert oversight, Judge Cannoni is creating an unbalanced and unconstitutional discovery process, which is obviously part of the grounds for an immediate appeal. Denying defense access to metadata and logs while offering only video recording may be an appealable issue because it violates due process under the 14th Amendment, and because it violates the right to present a defense under the 6th Amendment, and because it violates the Confrontation Clause under the 6th Amendment. In response, the defense could file an emergency motion to reconsider the ruling, or they could request an interlocutory appeal, and if either is denied, they could raise the issue in a federal habeas corpus proceeding as part of a due process violation claim. Again, how the defense responds or doesn't respond, as the case may be, is going to give us clues as to what their strategy actually is. At the end of the day, the judge's ruling is not a reasonable substitute for proper digital discovery. The video recording does not replace the need for metadata and expert verification. The police cannot be their own watchdogs. Independent oversight is necessary. The prosecution is receiving full access while defense gets compromised and unverifiable discovery process. Let's see how the defense responds. My guess is they will probably respond the same way they always have. They're saving it for major due process violations post-trial. So, what of the hearing yesterday? Well, we all thought that Judge Cannoni was considering removing pro hac vice lawyers. But I've also heard some attorneys suggest that she could be considering barring testimony from the ARCA witnesses. Either way, there's yet more implications. Judge Cannoni's consideration of either 1, removing the defendant's pro hac vice attorneys, or 2, barring testimony from the FBI witnesses, raises serious constitutional and procedural concerns. Either ruling would significantly impact the fairness of Trial 2.0 and could form the basis for immediate appellate review and federal habeas relief. So let's look at the first option. If Judge Cannoni removes the defendant's pro hac vice attorneys, this would violate the defendant's right to counsel of choice under the 6th Amendment. We saw this play out with Richard Allen's attorneys in the Delphi murders trial under United States v. Gonzalez-Lopez, 2006, the Supreme Court ruled that improper disqualification of a defendant's chosen attorneys violates the Sixth Amendment and results in automatic reversal of a conviction. If Judge Canoni removes defense counsel without legitimate cause, it violates the defendant's constitutional right to counsel. If the ruling is pretextual, i.e. punishment for uncovering prosecution misconduct, it strengthens claims of judicial bias and creates grounds for immediate appellate relief. If pro hac vice counsel is removed without due process, it may justify a motion for mistrial or interlocutory appeal. And so the second option, if Judge Canoni bars the FBI witnesses from testifying, this would be a violation of the defendant's right to present a complete defence under the 6th and 14th Amendments. Case law that supports this is Chambers v. Mississippi, 1973. The Supreme Court ruled that arbitrarily excluding defence evidence deprives the defendant of a fair trial. Washington v. Texas, 1967. A defendant has constitutional right to call witnesses in their defence, and a court cannot exclude relevant testimony without a legitimate legal basis. So, in this particular case, the FBI witnesses already testified in Trial 1.0 and were previously limited in voir dire. This is significant, and we'll come back to this in a minute. The FBI's testimony is exculpatory, meaning barring it prevents the jury from hearing evidence that undermines the prosecution's case. So if the FBI witnesses are excluded, it strengthens the habeas claims of judicial bias and due process violations. But what if Judge Bev decides to disqualify defence and bar the FBI testimony? That would create overwhelming grounds for appellate relief and immediate federal intervention. This would be covered by cumulative error that we've talked about in the last video. Under Taylor v. Kentucky, 1978, multiple errors that create an unfair trial violate due process. And Bracey v. Gramley, 1997, a judge's bias in favour of the prosecution is a basis for federal habeas relief. This might be a great point to introduce the defence strategy of raising it immediately during the current federal habeas petition, because it's a new set of circumstances that has occurred just now since the habeas petition was filed. In any case, either or both rulings would severely undermine the fairness of Trial 2.0, because removing pro hac vice counsel violates the defendant's right to choose their attorney and may justify an immediate appeal. Barring FBI witnesses prevents the defence from presenting crucial evidence and violates due process. And if both rulings are issued, the case becomes a textbook example of cumulative due process violation warranting immediate federal relief. But wait, there's more. If you recall, in Trial 1.0, Judge Canoni already remedied Rule 14 sanctions by enforcing a voir dire of the FBI's witnesses. This effectively awarded the prosecution pre-testimony depositions, and then she further awarded them by double sanctioning and applying limits to their testimony. If she were to repeat that process for the same Rule 14 violations addressed in Trial 1.0 already, the implications would include double jeopardy in the context of witness sanctions. The defence has already been penalised for this in Trial 1.0. Fundamental unfairness and judicial bias. Selective enforcement of sanctions only against the defence. Violation of due process and the right to present a defence. Arbitrary limitation of exculpatory testimony. And potential appeal and habeas grounds. Excessive and pretextual sanction could warrant immediate appellate relief for federal intervention. So, what is double jeopardy in the context of witness sanctions? Although double jeopardy usually applies to defendants, the principle that a party cannot be punished multiple times for the same conduct applies here. Under United States v. Halper, 1989, Punishment must be proportionate and cannot be reimposed multiple times for the same offence. Under Bullcoming v. New Mexico, 2011, a witness cannot arbitrarily be barred from testifying if they have already complied with procedural requirements. To apply that case law to this situation, the FBI witnesses were already subjected to voir dire and had their testimony limited as a sanction in Trial 1.0. Sanctioning them again for the same alleged violation in Trial 2.0 is a form of double punishment against the defence. The prosecution has already received more than a fair remedy, i.e. pre-testimony depositions and limited testimony. Any new sanctions effectively retries the same issue, which is fundamentally unfair. Furthermore, if Judge Cannoni applies other sanctions on the FBI witnesses, but does not similarly scrutinise prosecution witnesses, it constitutes selective enforcement of sanctions. Under Wardius v. Oregon, 1973, discovery sanctions may be reciprocal and fairly applied to both sides. And Brady v. Gramley, 1997, judicial bias is due process violation, warranting habeas relief. How this case law applies here: the prosecution witnesses were never subject to pre-testimony depositions or limitations, despite their testimony being suspect. Defence witnesses are being unfairly targeted, making the trial fundamentally biased in favour of the state. And a judge who repeatedly sanctions the same witnesses is acting as an extension of the prosecution rather than a neutral arbiter. Arbitrarily barring or limiting exculpatory witnesses violates the defendant's Sixth Amendment right to present a full defence. Under Chambers v. Mississippi, 1973, defendants have the right to present exculpatory witnesses, and arbitrary exclusions violate due process. Washington v. Texas, 1967, the state cannot selectively block defence witnesses from testifying. How this case law applies here is that the FBI witnesses are exculpatory and contradict the prosecution's version of events. Judge Cannoni is using procedural rules to limit defence evidence while allowing the prosecution to present unchallenged witnesses. If these witnesses are barred or further limited, the defence is being denied a fundamental trial right, which may cause potential appeal on habeas grounds if Judge Cannoni imposes a new sanction on the ARCA witnesses. The defence could argue that judicial bias and selective enforcement of sanctions are only being applied to defence witnesses, and in this case multiple times. They can also argue violation of due process if the FBI witnesses are arbitrarily limited again, because it denies the defendant of a fair trial. And of course, the violation of the right to present a defence. Any ruling barring or severely limiting defence witnesses is unconstitutional. In summary, any additional sanctions would be unconstitutional and appeal-worthy. So sanctioning the FBI witnesses again amounts to punishing the defence twice for the same alleged Rule 14 violation. The prosecution already received a remedy in Trial 1.0, so any additional sanctions are excessive and unfair. This constitutes judicial bias and a violation of the defendant's right to present a full defence. If the judge imposes further sanctions, the defence should file an interlocutory appeal and seek federal relief. Furthermore, the prosecution and Judge Cannoni's suggestion that the defence's statements regarding payment to the FBI witnesses are sanctionable is legally and factually baseless. The prosecution was not prejudiced by the defense covering the FBI witness expenses after Trial 1.0, and such payments are common and permissible in criminal litigation. So let's break it down. The FBI witnesses were independent and provided exculpatory evidence voluntarily. We know that the FBI provided it due to TUI obligations, i.e. it was not defence initiated, even though that's what the prosecution would like to claim. The FBI was already conducting an independent investigation and formed its opinions before the defence or the prosecution were even notified. Under TUI regulations, federal employees must obtain authorization before testifying, meaning their testimony was pre-approved by the federal authorities and their findings were not influenced by any payment from the defence. The FBI had an affirmative duty to provide the evidence. The FBI's exculpatory findings were disclosed as part of its legal obligation, not due to any defence arrangement. The prosecution would have received the same exculpatory reports regardless of defence involvement. And they did, we know they did. They admitted that they did. Why this matters? Because the FBI's credibility was established before the defence ever paid any expenses. Their findings existed prior to their involvement with the case, preventing any claim of bias or influence. The prosecution had equal access to the FBI's reports, and even at the time that they saw them, they said it supported their version of events. From what we can ascertain from the hearing yesterday, the defence's statements were accurate at the time of Trial 1.0. The defense accurately stated that the FBI had not been paid for their testimony because the FBI was acting pursuant to TUI obligations, not a defense contract. Their investigative filings were already official before they were called as witnesses. Also, paying a witness for expenses after testifying is common and ethical. Rule 3.4b of the ABA Model Rules of Professional Conduct allows attorneys to reimburse expert witnesses for expenses and time. Massachusetts Rule of Professional Conduct 3.4g explicitly allows reasonable compensation for an expert witness's time and expenses and reimbursement for travel and accommodation. Why this matters? Because the defence did not hide payment. The issue simply had not risen yet. No misrepresentation occurred because the payment was made after Trial 1.0, not before. The prosecution's complaint is an attempt to create a discovery violation where none exists. Under case law United States v. Cervantes Pacheco, 1987, compensating a witness post-testimony does not retroactively invalidate their prior testimony. Giglio v. United States, 1972. Misconduct occurs when payments influence testimony, not when payments cover expenses after testimony. In addition, the prosecution was not prejudiced by the defence paying the FBI witnesses' expenses after Trial 1.0. Prejudice requires unfair surprise or an inability to counter evidence. The prosecution had prior notice of the FBI's reports and findings. The prosecution knew about the FBI's conclusions before trial. The FBI's findings were produced through independent investigation, not defence influence. The prosecution had the same opportunity to cross-examine these witnesses and rebut their findings. Not to mention, they also had the opportunity to call them if they wanted to. The defence did not gain any unfair advantage. The defence did not pay for a favourable witness. The FBI was legally obliged to testify. The prosecution could have deposed the FBI witnesses at any time. If the prosecution believed the FBI was biased, it could have raised that issue in Trial 1.0, but it did not. Why this matters? Because prejudice requires that the prosecution was actually harmed by the defence's actions. Here, the prosecution had full access to the FBI's findings and could have challenged them. Any claim of prejudice is purely speculative. Under United States v. Aguirre, 1976, failure to disclose information is only prejudicial if it affected the trial's outcome. Coles versus Whitley, 1995. Prejudice requires suppression or manipulation of key evidence. I wonder if that's what Mr. Brennan was getting at when he went, shh, keep it a secret. Any sanctions Judge Canoni proposes are going to be legally unjustifiable, if not outright unconstitutional and appealable. This is because sanctions for payments after testimony violates due process, and because no prejudice means no justification for sanctions. And finally, because Judge Canoni would be seen to be engaging in selective enforcement. That is, prosecutorial witnesses, state, police, forensic analysis, etc. have also been paid for. If only defence witnesses are scrutinised, it constitutes judicial bias. Because under Wardius v. Oregon, 1973, sanctions must be fairly applied to both prosecution and defence. And under Bracey v. Gramley, 1997, judicial bias that favours the prosecution is unconstitutional. In summary, there is no legal basis for sanctions. The FBI's testimony was independent, formed before any defence involvement. The defence statements at trial were accurate at the time. The prosecution had full access to the FBI's findings and suffered no prejudice. Payments for expert witness expenses after trial are completely legal, and if sanctions are imposed, they would constitute judicial bias and due process violations. Judge Canoni's disparate treatment of the defence and prosecution suggests a lack of judicial neutrality and could indicate she has already made up her mind. Her conduct raises serious due process and judicial bias concerns, especially given that she scrutinised the defence extensively over case law, yet allowed the prosecution to speculate without citing any legal authority. She applied a much lower standard of proof to the prosecution, failing to ask any clarifying questions while interrogating the defence. Her behaviour aligns with a pattern of favouring the prosecution in discovery rulings and sanctions. These are issues because a judge should be equitable in questioning both sides. It's her duty to ensure that both parties are held to the same standard of proof and legal argumentation. This is covered by all the case law we've already stated, and it's applicable here because by grilling the defence on case law while letting the prosecution speculate freely, Judge Canoni failed to apply an even-handed approach. A judge questioning one side while passively accepting the other side's assertions without scrutiny suggests partiality. Disparate treatment suggests a prejudiced ruling. If a judge is not engaging both sides equally, it may indicate that she has already decided the outcome and is simply giving the appearance of consideration. The signs that she may have already made up her mind are 1. Unbalanced questioning, which we all noted. Rigorously questioning only one party suggests the judge is searching for a reason to reject their argument while accepting the other side's argument at face value. 2. Applying different standards of proof, holding the defence to strict legal citations while allowing the prosecution to provide mere speculation suggests an unfair standard. And 3. The pattern of favouring the prosecution that she has exhibited through trial 1.0 and now into pre-trial 2.0, where she has consistently ruled against the defence on procedural matters while giving leeway to the state, it is strong evidence of bias. In summary, Judge Canoni's unequal treatment suggests she is more concerned with finding fault with the defence than genuinely analysing the prosecution's arguments. By applying different standards of scrutiny, she has signalled that she is inclined to rule against the defence, regardless of legal merits. We have already discussed over multiple videos, including this one, all the possible legal remedies for judicial bias. But just to summarise, they can file a motion for judicial recusal, they can object to unequal treatment in real time, they can seek interlocutory appeal for unfair rulings, or they can raise the issue in future habeas petition. In any event, Judge Cannoni's unequal treatment strongly suggests bias. A judge must question both sides equitably and apply the same standard of proof. Judge Cannoni's actions suggest she has already made up her mind about the issue. If this pattern continues, the defence should formally object, seek interlocutory appeal, or move for her recusal. If Trial 2.0 proceeds under these conditions, this judicial bias must be included in post-trial appeals or federal habeas proceedings. The last topic that I promised to discuss was the difference between emergency appeals versus interlocutory appeals. And it can get confusing because an emergency appeals to the Massachusetts Appeals Court may or may not be classified as an interlocutory appeal depending on the nature of the ruling being challenged. So what's an interlocutory appeal? It's an appeal of a trial court ruling made before the trial has concluded. It is typically used to challenge a significant ruling that could materially affect the outcome of the case and is usually only permitted in specific circumstances. Massachusetts Rule of Criminal Conduct, Procedure 15, governs interlocutory appeals in criminal cases. Common examples of rulings that may qualify for interlocutory appeal include suppression of evidence, either the prosecution or the defence may seek review, denial of a motion to dismiss on double jeopardy grounds, which falls under Abney v. United States 1977, a disqualification of defence counsel under United States v. Gonzalez-Lopez 2006, or exclusion of key defence witnesses, Chambers v. Mississippi 1973. The key requirements for interlocutory appeals is that they're only allowed if the issue is one that cannot be remedied by an appeal after trial. So, what's an emergency appeal? An emergency appeal is any expedited request for appellate review of a trial court ruling that requires immediate intervention. This can include interlocutory appeals, i.e. pre-trial, but it may also involve a request for extraordinary relief under other legal mechanisms. Common types of emergency appeals include petition for a writ of mandamus, which is ordering the trial judge to take or refrain from a specific action. Petitions for a writ of prohibition, which is preventing the trial court from proceeding in an unconstitutional manner. And immediate requests for a stay of proceedings, pausing the trial while appellate review is pending. Massachusetts Rule of Appellate Procedure 6 allows for emergency relief, including stays and interlocutory review. Which one applies in the case where Judge Cannoni disqualifies defence counsel or bars FBI witnesses? An interlocutory appeal is likely appropriate because these rulings directly impact the defendant's right to a fair trial, and they cannot be effectively remedied after the trial has concluded. So if the Massachusetts Appeals Court declines immediate review, the defence can consider filing for extraordinary relief via a petition for writ of mandamus or prohibition. So in summary, given the large amount of cumulative error that we have outlined in the last, I can't even remember how many videos now, we've seen very little action from the defence, although it looks like plenty could be taken. This indicates to me that the defence has a different strategy, and it's looking very much like cumulative error doctrine, which we discussed in the previous video. I will add an end screen to direct you to that video if you haven't seen it yet. So I guess the final question that you'll all be asking me is, what do I think Judge Cannoni's going to do? As I've been saying all along, even way back at pre-trial proceedings for 1.0, the judge is only going to make decisions that she can plausibly deny. And I can't see how either rulings, whether we're talking about disqualifying defence counsel or barring FBI witnesses or even limiting their testimony, would have any legal basis whatsoever. I don't think she's considering cumulative error in her reasoning at all. I think she feels secure in state law supporting each isolated decision or ruling that she's made. But if she's doing this purposely in collusion with the Commonwealth to give the Commonwealth a better chance at appealable issues later on, then she's only adding to the strength of cumulative error claims that the defence can make to the federal court. So in this case, I think that she was absolutely helping out Meatball with his psyop and trying to even out the PR playing field, in which case the damage has been done and she will most likely deny the Commonwealth's motion for sanctions. She has nonetheless given the defence more ammunition to request her recusal again. I would be extremely surprised if we don't see this occur prior to trial 2.0. But I do have faith that the defence team knows exactly what they're doing and why they're doing it. So let's just hang in there and see what they have up their sleeves. We could be pleasantly surprised.